So it's important for you to understand what to expect during the sentencing hearing. If you've been charged with a federal crime, you should know that the vast majority of people who face charges in federal court face a sentencing hearing at some point. And that's the reason that I recommend that you really prepare yourself early. You're definitely going to need a defense attorney to help you, but you definitely don't need a prison consultant. You need to educate yourself on just developing an awareness, a literacy with how all the proceedings work, including the pre-sentence investigation report, your responsibility in creating a narrative, how you could prepare for allocution, how you could build a comprehensive mitigation strategy, in what ways can you prepare yourself for administrative relief later. But you probably want to know also, well, what actually happens at a sentencing hearing, especially if you've never been through the system before? Let me kind of walk you through that, okay? Through our previous lessons, which you should be able to follow just by going to our website at prisonprofessors.org, click on lessons, and go through the entire course on lessons before, to prepare before sentencing. You'll know that there's the probation officer is going to prepare a pre-sentence investigation report. Both the defense attorney and the prosecutors are going to have a chance to review it. You should have a chance to review it to correct any factual errors or to make sure that PSR accurately reflects your life. Then there might be discrepancies, and hopefully your defense attorney and prosecutor can work them out on their own. Most likely they're not going to be able to work out everything, in which case that's what the sentencing hearing, it will begin with that resolution. So the judge will ask, have you come to a resolution on this matter? And they'll say no, and then he might ask the prosecutor, well, what's your position? And an example of a discrepancy might be whether the base offense level should be a level 26 or a 28. Okay, probation officer recommended 28. Prosecutor agrees with the probation officer. Your defense attorney says, no, it should be a level 26. There was no resolution. The judge will listen to the prosecutor. The judge will then listen to the defense attorney. And then the judge will make what's called a finding of fact, either agreeing with your defense attorney or overruling your defense attorney's motion for clarity or a lower sentencing guideline. And so that's what it starts with. That entire process of assessing the PSR, it can last 20 minutes. It could last several hours because there's, every case is different. Every individual is different. But that's how all sentencing hearings begin. Following the resolution of the PSR, the judge will move into the more substantive matter of sentencing. And he may ask the prosecutor to speak first regarding the prosecutor's version of events and get a recommendation, or not only a recommendation, but maybe a verbal supplement to what the prosecutor said in their briefs, sentencing briefs. And you should expect the prosecutor to be really well prepared, whether they speak before your defense attorney or after your defense attorney, in arguing for a severe sentence. So that's just how it begins. That's the prosecutor's job. It's not personal. It's just their job. They are going to advance their career by working to advocate for a tougher sentence. Their client is not you. Their client is the government and the people. So that's what they do. So you have to just understand the nature of the proceeding. And then you should be anticipating, well, what can I do to counterbalance what I anticipate the prosecutor is going to say? One thing you can expect the prosecutor to say is, Your Honor, the defendant didn't self-surrender. The defendant is only sorry because he got caught. Had he not got caught, he'd still be doing the same thing. Kind of expect that line of argument from any prosecutor. That's their job. Your defense attorney is then going to speak, and they're going to make a case on why you are worthy of a lower sentence. They may cite case law. They will speak about you in the third person, the defendant, my client, things of that sort. Okay, they will go through this entire process of why you are worthy of a lower sentence. So just anticipate that the judge is going to hear from both the prosecutor and the defense But the judge has probably once worked as a prosecutor or once worked as the defense attorney or maybe worked in both roles. And they know that is the process. They're still going to listen. And then the prosecutor is going to ask if there are any victims in the courtroom that might want to make a victim impact statement. And he's going to listen to all of those people if any of those people show up. And then the defendant at some point, the judge at some point may ask the defense attorney, does your client want to address the court? That's the allocution statement that I spoke about in a previous lesson. I believe it's super important for you to prepare that allocution statement, just like I think it's important for you to prepare before the pre-sentence investigation report. And I think it's important for you to prepare your personal narrative and your character references and a very comprehensive mitigation strategy, because all of these works will help you influence the outcome at various stages of the journey. After the judge listens to you, he may ask the prosecutor and the defense attorney whether they have anything further to add. If not, then he will say, I'm ready to pronounce sentence, and he'll ask the defendant to rise, and then he will pronounce sentence. Then he will go through a series of factors that explain why he arrived at that sentence, because there are rules. I think it's Title 18, Section 3583, that provides the very clear rules that a judge has to follow when he is imposing sentencing. And this is super important for appellate matters because he's got to follow the rules of criminal procedure. And you should educate yourself on those rules of sentencing and criminal procedure so that you can position yourself for the best possible outcome. Again, I don't think you need a consultant of any kind. I think you need to invest a little time. You are fighting for your liberty, and that's more important than anything because you only have so much time on this earth, and you certainly don't want to spend it inside of a federal prison, or you don't want to spend one day longer. You want to focus your life on the best possible outcome and returning to society with your dignity intact, understanding that there are always more opportunities in the future than in the past. That's why I really urge you, spend your time using all of our free resources at prisonprofessors.org. Go through every article, use our artificial intelligence, and ask questions on our bot. If you need somebody to guide you, I only recommend Justin Paperny, who's the founder of whitecollaradvice.com and a sponsor of our nonprofit. You can participate in his free interactive webinars at whitecollaradvice.com/nonprofit. And he'll respond to your questions in real time. I just don't have the capacity to do that because my focus is really on changing the system. But I want you to focus on changing your life and positioning yourself for the best possible outcome. That's why we make everything free at prisonprofessors.org. I am Michael Santos. I do hope that you will subscribe to us so that you can get our newsletter. And I hope that you will follow us on social and be part of the change that you want to see in the world. Be cool.